She had the permit. She passed the background check, completed the training, waded through every bureaucratic delay, paid every fee, jumped through every hoop the state of Hawaii required. She did everything right. She earned the legal right to carry a firearm for her own protection. And then she walked into a grocery store, and under the law that the state of Hawaii passed in 2022, that ordinary act, walking into a grocery store with a legally permitted, legally carried firearm, made her a criminal. Not because the store owner objected. The store owner had never posted any sign, never said a word, never indicated any preference either way. But under Hawaii's new rule, silence was no longer neutral. Silence meant no. And carrying a firearm into any business open to the public, any gas station, any pharmacy, any coffee shop, any laundromat, without the owner's express written or verbal permission was now a criminal offense. She had a permit. She had a right. And the state of Hawaii had found a way to make both of them completely worthless in daily life. 3 days ago, the Supreme Court of the United States looked at what Hawaii did to her and to every permit holder in that state, and issued a ruling that changes the rules for gun owners not just in Hawaii, not just in one region, but across every state in this country. This is Wolford v. Lopez, decided June 25th, 2026. And if you carry a firearm or you live in a state that has been quietly expanding its list of places where your permit means nothing, you need to understand exactly what this court just said, and exactly where the fight goes from here. Before we go further, this channel covers every Supreme Court ruling, every new gun law, and every change to your Second Amendment rights the moment they happen. Not after the fact. Not buried in a comment section weeks later. If that is the information you want before you need it, subscribe right now and hit the notification bell. 2 seconds, free. The next ruling that affects your life will be waiting for you the moment it drops. Now let's talk about what just happened, and why it matters to you today. To understand why Wolford v. Lopez is a landmark decision, you need to understand the game that was being played, and how close it came to working. 4 years ago, the Supreme Court held in New York State Rifle and Pistol Association v. Bruen that the Second and 14th Amendments protect the right to carry handguns outside the home for self-defense. That 2022 ruling was massive. It struck down New York's law requiring gun owners to prove a special, individualized need before they could carry in public. It said, the right to bear arms is not a right that evaporates the moment you step outside your front door. States that had been restricting public carry for years saw Bruen as a threat. Several of them immediately went to work finding a workaround. Hawaii was the most aggressive. Hawaii responded by replacing its old law on carry permits with new laws that achieved a similar result. They could not ban public carry outright. Bruen had just made that unconstitutional. So they did something more sophisticated. They flipped the default rule. Here's what that means in plain language. Under normal common law, if a business is open to the public, you are presumed to be welcome unless the owner explicitly tells you otherwise. You can walk into a grocery store, a gas station, a barbershop without asking anyone's permission. That has been the legal default in America for over 2 centuries. Hawaii reversed it, specifically for gun owners. Hawaii's new rule required concealed carry permit holders to obtain express authorization through signage, verbal permission, or written permission from property owners before carrying a firearm into any business open to the public. Without that express permission, carry was banned and criminal charges could follow. In gun rights circles, this became known as the vampire rule. Like the folklore version of a vampire who cannot enter your home unless invited, Hawaii's law said gun owners could not enter any public business unless explicitly invited. Every other American could walk in freely. Only licensed, permitted, law-abiding gun owners had to beg for permission first. As Justice Alito summarized the effect of the law, citizens would be barred from entering many places that people routinely visit in the course of their daily routines, such as gas stations, convenience stores, restaurants, coffee shops, drugstores, grocery stores, big box stores, home improvement stores, barbershops or hair salons, dry cleaners, and laundromats. Think about what that means in practice. You have a permit. You have a legal firearm. You leave your house in the morning. And from the moment you step outside, virtually every stop you make on an ordinary day, every errand, every routine task, requires you to first locate the owner, find a way to ask permission, and hope they say yes before you can exercise a constitutional right you already earned. That is not carry. That is permission-based existence. And Hawaii knew exactly what it was doing. The case before the court involved Jason Wolford and 2 other residents of Maui County who possessed concealed carry permits, along with an organizational plaintiff whose members held such permits. They filed suit in federal court seeking injunctive relief, arguing the law violated their constitutional rights. The district court enjoined enforcement of the law, but the Ninth Circuit reversed that injunction, siding with Hawaii. That Ninth Circuit decision is important to understand. It meant that for a period of time, the most aggressive gun restriction Hawaii had ever designed was actively being enforced against permit holders. The lower court had looked at what Hawaii built, looked at Bruen, and decided it could stand. Then it reached the Supreme Court. The Supreme Court ruled 6-3 in Wolford v. Lopez, striking down Hawaii's law. Justice Samuel Alito wrote the majority opinion. His language was direct and unsparing. Hawaii's law at issue here violates the constitutional right to keep and bear arms, Alito wrote. This regime hobbles what the Second Amendment protects, the right of Americans to carry arms for self-defense as they go about their daily lives. The court's reasoning went to the core of what Bruen established. The law severely hampers the ability of law-abiding citizens to exercise the right Bruen recognized as they go about their daily lives. And when the government tries to impose that kind of burden on a constitutional right, it needs to show a genuine historical tradition of similar regulation going back to the founding era. Hawaii tried. The court found every historical argument they offered either irrelevant or outright disqualifying. Hawaii's colonial and early state law analogs consisted almost entirely of laws that prohibited unauthorized hunting of deer or small game on someone else's private property. These laws targeted unauthorized hunting and applied to land where game could be found, not retail establishments that residents frequent as part of their daily routines. Those laws had little, if any, impact on the Second Amendment's central objective of protecting the fundamental right to self-defense. And then the court went further. Hawaii also cited an 1865 Louisiana statute as historical precedent. The court rejected it with language that should follow that argument forever. The 1865 Louisiana statute was enacted as part of the notorious Black Codes to disarm blacks and leave them defenseless against attacks. Hawaii's claim that this tainted artifact from Louisiana's Black Code illuminates the original understanding of the right to keep and bear arms cannot be taken seriously. Hawaii's entire legal foundation, every historical argument it built over years of litigation, collapsed, and the law fell with it. Now here is where you need to pay close attention, because this ruling is significant. It is a genuine, substantial win for every gun owner in America, and it is also not the end of this fight, not even close. Misunderstanding what this decision does and does not accomplish could cost you. What this ruling definitively establishes is this. A state cannot flip the default rule to make permit holders beg permission from every business owner just to exercise their carry rights in ordinary daily life. Hawaii's shift from the common law rule unquestionably imposes a new and significant burden on the exercise of the right recognized in Bruen. That burden is now unconstitutional. What this ruling does not do is eliminate the concept of sensitive places. The court has consistently acknowledged that certain specific locations, courthouses, schools, government buildings, can be designated off-limits for carry. Wolford did not change that. What it stopped is the practice of expanding sensitive places so broadly that they swallow the right entirely. There's a constitutional line between a specific sensitive location and a blanket policy that effectively bans carry everywhere a person goes in their daily life. Hawaii crossed that line. The court drew it back. And here's the broader implication that every gun owner in every state needs to understand right now. Hawaii was not alone in passing this kind of law. Maryland passed legislation after Bruen that expanded the list of what it considered a sensitive place where concealed carry was not allowed, including government buildings, mass transit facilities, school grounds, public demonstrations, state parks, healthcare facilities, and places of amusement including museums, stadiums, and racetracks. Similar cases from Maryland are working their way through the courts right now. Wolford did not decide those cases, but the reasoning in Wolford speaks directly to them. The Supreme Court has now drawn a clear constitutional principle. You cannot use sensitive places as a tool to make public carry a practical impossibility. Any state law that produces the same effect Hawaii's law produced, stripping permit holders of their ability to carry during ordinary daily activities, is constitutionally suspect under this ruling. The National Rifle Association called the decision a major victory for the Second Amendment. Law-abiding gun owners will no longer be forced to beg for special permission simply to exercise their constitutional right to bear arms in public places, said John Comerford, NRA-ILA Executive Director. So what does this mean for you? Specifically, practically today? If you live in Hawaii and hold a carry permit, the vampire rule is dead. The Ninth Circuit's decision upholding it has been reversed and remanded. You no longer need to find and obtain express permission from every business owner before entering with a legally permitted firearm. The common law default, that you are presumed welcome in a business open to the public, has been restored. If you live in another state that passed similar legislation after Bruen, laws that expanded sensitive places to the point of making carry nearly impossible in daily life, watch this space carefully. Wolford gives challengers a powerful constitutional framework, and the lower courts will be applying its reasoning to those laws in the months ahead. If you live in a state with straightforward shall-issue permit laws and no post-Bruen expansion, this ruling reinforces what you already had. The court has now made clear across 3 consecutive major decisions, Heller, Bruen, and now Wolford, that the Second Amendment means what it says. The right to bear arms is not a right that exists only inside your front door. It is not a right that requires government permission at every turn. It is not a right that can be designed out of existence through creative legislation. Armed does not mean dangerous. A permit does not require daily permission. And a constitutional right cannot be made into a privilege that disappears the moment a law-abiding citizen steps outside. That is what the Supreme Court said on June 25th, 2020X. Know it, remember it, and stay close to what comes next, because the states that have been fighting this battle are not finished yet. Subscribe. Hit the bell. The next ruling will not wait for you, neither should you.